Hello, everyone, and welcome back to the show. Thanks so much for joining us, and thanks so much for sending in your questions for our guest today, attorney Jack Jernigan. We are learning so much about debt collection and what the law says out there when it comes to harassing phone calls from debt collectors. Thank you for sending in your questions on Facebook, on Twitter, and by email. You have some great questions, and we're going to get right to them. And our first question this time around, Jack, is can I really be arrested if I don't pay a debt?
This is a great question, Shauna, because it's a very common tactic of debt collectors. If not outright lying to them and saying they will be arrested, they will strongly imply that the sheriff is going to come and arrest them. And this is absolutely untrue. It's a lie. You can virtually never be arrested for owing a debt unless you've committed some type of outrageous fraud. I've just never seen anybody, so do not believe that. And if you can get them on tape saying that, even better.
Even better, but that is a common tactic.
Yeah, and that's a good note. You know, if these harassing calls are coming, rather than ask somebody to trust you, and when you say it happened 3 times a day, if you can have your caller ID and record the voice messages, if you can record that the calls came from that call center, if you can audio tape them on the phone, even put them on speakerphone on your home phone and use your voice recorder on your smartphone and get that proof, because you don't want to have a he said, she said later on if it's really getting to be ridiculous.
That's true, because in Louisiana it is legal to tape a conversation without telling them, I am taping this conversation. In some states that's not legal, but in Louisiana you can just hit the record button if you have that capability and record any conversation.
Yeah, as long as one person knows.
Correct.
That the recording is taking place.
One person involved in the conversation.
That being you.
Yeah, that being you, exactly.
Of course.
Exactly, but it just speaks to the fact that people, you know, these debt collectors can really be intimidating and threatening.
They can, and that's just part of their gimmick or their shtick or what they use to get you to send them money. And over time, it's a hard job. I mean, I sympathize with them a little bit because it's all commission, and they have these overseers essentially whipping them to pull in this money. I suggest if they're being
asked to do that kind of work, they need to go find another job so they can respect themselves and they can have the respect of their community members. But if they're doing that kind of work.
And one of the things that they also threaten is to, do damage to your credit report. Now that's a valid threat. That they can do and will do, right?
That they can do, they often do. They certainly will threaten it. But they are allowed to do that. If it is your debt and you owe it and you're delinquent, they can report it to the credit reporting agency. And there are ways to challenge that, however, if you don't owe that debt or if you are not delinquent on that debt.
I'll add too, sometimes it's worth having an attorney such as you or others who handle this try and clean up your credit history. And if you challenge even valid debts you have had, by using those form letters, but better if somebody who really knows how to navigate these waters. If you had a valid debt that you were delinquent on, but they don't they don't dot their I's and cross their T's in proving it up, you can have it removed from your credit history. And good credit means loans at a better rate. It means a lot towards buying a house, just a lot of good things. So challenge a lot of that debt, even if it's one that might be technically more or less accurate, because if they don't follow up, then you get it off your credit.
That's true. That good credit is so important these days. Everybody knows that, and that's why it's such a threat that these bill collectors use. But everybody should pull their credit report regularly. You can get it free once a year, and send letters to the agencies if there are debts on there that are reported incorrectly.
Right. Another question here. It says, I've offered to send a check every month to a collection agency for my monthly payments, but they're insisting that they debit my checking account instead. This is something that we touched on during the last show, but just in case some of our viewers this time around missed it, this I think is really important. The company is saying that that is their policy. I don't want to give them access to my account. Can they really do that?
They can insist on it, but you don't have to do it. Never do it.
Right.
You can send them a check. You don't have to give them any information over the phone. And I encourage you not to, especially a stranger, to give any kind of bank account information, Social Security information over the phone. Never do that. You do not have to do that.
No matter what they say.
You did correct.
And one good reason not to do that, not to give any important information over the phone, is it might not be a debt collector. It might not be your bank. It might be a fraud out there who wants to steal money out of your bank accounts. And this is a very white-collar crime. It's the fastest-growing area of white-collar crime. And the elderly, we mentioned this before too, are the most susceptible to falling victim to debt collectors and frauds who would steal their information and then steal money out of their accounts.
So on the phone or over the internet, never give that information out.
Absolutely.
Yeah. So in trying to collect their money, oftentimes they will try to collect money from your wages. They'll try to garnish your wages. And this question says, will I be informed before my wages are garnished? Is there anything I can do to stop it?
Well, we talked about this before, and in order to garnish your wages, they have to go through a number of steps. One thing is hire a lawyer and serve you with a petition for damages. So you will actually get served by the sheriff before they can do anything. And then that gives you an opportunity to respond, to file an answer, to get extra time. And at that point, I encourage you to speak with an attorney and explore your rights, find out what the best way to go is. But they have to do all that before they can garnish your wages.
Mm-hmm.
And on that note, and I think it actually relates to another question, just so our viewers understand, you can talk to a lawyer and perhaps get help that will not require you to come up with cash money or write a check out of your bank account. Am I correct on that?
You're absolutely correct. And there's a number of routes available to you depending on your financial circumstances. So a lot of lawyers will talk to you without charging you any or certainly a big fee up front, and say, this is how you should handle this.
Okay. And if there's debt collection practices that are being violated, that lawyer may be able to take the case, no charge throughout the litigation or throughout the handling of the case, because the lawyer is optimistic that he or she's going to prevail and force the bad debt collector to pay your attorney fees, correct?
Correct.
We talked a little bit about payday loans, but what about the rent-to-own situations?
Boy, these are, to me, analogous to payday loans.
Yeah.
They're just, you end up buying furniture at 10 times its value.
Right.
It's another outrageous ripoff. You know, you get to fill up a living room, right, for just a small bit of money, but then you pay on it for maybe 10 times longer than you would if you just found it at the store on sale.
Oh, it's terrible. There's no reason to do that.
Yeah, and same with installment loans and title loans.
Oh, title loans, car title loans, definitely avoid these. These are always high interest. I see people getting them in Mississippi. I'm not sure, I don't see them in Louisiana, but sometimes people will go over to Mississippi where the casinos are and get a car title loan. I've seen 1,000%.
1,000%.
Outrageous.
Oh my gosh. Old parking tickets. Now this is an issue for a lot of people.
Talk about this. Well, I've just seen a lot of it, and many of our viewers out there, it is to me, we talked about how these agencies buy old debts. I've seen it happen in the city of New Orleans, where old traffic fines, traffic citations were from before Katrina, before 2005. Some of them are 4, 5, 6 years old, which, unless you have fled the state, which might interrupt the timing, the 3-year time limits, it's too late to collect on them. But I have seen it happen many, many times. People are getting these bills saying you have to pay the fines on these parking tickets, you have to pay the fines on this this traffic offense, and what I believe is that it's too late for them to collect on those. Now, since if it's coming from the courthouse, if it's anything that seems to be under the auspices of the courthouse, you want to be careful you don't get in contempt. So you want to report to the courthouse and say, I believe this debt is too old. I want you to send that certified letter saying, prove this debt is valid. But because it's a state agency, I'm not sure how much the rules change, but I would definitely try and see a lawyer about paying a debt that is that old.
And we're going to see more and more of this with these red light cameras.
Oh, yeah.
Because so many people are getting these red light tickets from these cameras, and so I think it's just going to increase dramatically during the coming years.
Yeah. Okay. And before we go, also, you wanted to talk about arbitration clauses.
This is something that just because I see it so often across the spectrum. When you get a cell phone, when you enter into you borrow money, you do all kinds of business negotiations. You've got a big contract, 1 or 2 pages, you sign on the dotted line, you initial here, you initial there. Very often they have in it something that's called an arbitration clause. Arbitration is an alternative to being able to have your case handled in the courthouse. I'm against them. It's a bad idea. In arbitration, you win, you lose, that's it. It's over. You don't get to appeal it. By and large, many of these arbitration companies get all their business from these business owners who put the arbitration clauses in their contracts. So if you're aware of an arbitration clause, the moral of the story is say, I don't want to do business with you if you're going to have arbitration in there. If you read it carefully, you can opt out if you send them a written proof within a few days. But for more information, we'll try and give you some details on our website on that, because it's a big deal.
And we have less than a minute here, so I'm just going to ask you before we leave if you would just leave our viewers with some important things that they need to know when it comes to dealing with debt collectors, if in fact they are being harassed.
I think the most important thing is to know your rights, like we talked about, but also don't delay. The sooner you act on either trying to settle a debt or speaking with a lawyer, the better. A lot of people will make the mistake of just ignoring it, and it just compounds, it snowballs, interest runs, fees run, the debt gets higher and higher. So act now, don't wait, I believe is the most important thing.
I think that's really, really good advice. Don't ignore it. It is not going to go away. Well, guess what? We have to go away because we are totally out of time. That's all that we have, all the time that we have for today's show. But if you would like to learn more about your rights when it comes to debt collection or see some of our past shows, please visit our website.
You can go online to johnredmannpoa.com or jrpoa.com to get more information about everything discussed on the show. You can also watch every episode of our show on the website as well. Thanks again to Attorney Jack Jernigan and all of you for supporting us each week. We'll see you next time on John Redmann, Power of Attorney.